morning to everyone. We'll now start our first session for the day. May I call upon Mr. K. N. Bhat, Mr. Krishnan Venugopal, Koka Raghav Rao, Mr. Amit Kapoor, for our panelists for the day. Mr. Bhat will chair the session and also be the speaker because Mr. Nariman is unable to attend this session.
Good morning, everybody. Starting with an apology, Mr. Nariman was to preside over this function today, this particular session. And I was to make some presentation a little later. So what I have decided is I have decided to give up my later portion and be a presiding only, so that this is much easier. You know, each of the speakers, I would like to hear them, and if there is anything at the end, I may add something to them. But giving an introduction, you know, the tribunals were not known to begin with. Only industrial tribunal we had. It is actually a creation of the 42nd Amendment in 1976. The 42nd Amendment Act, what it did was, it did a number of tinkering with the Constitution and its wholesale substitution also. But one of the major things which they wanted to do was to take away the powers of the courts. Article 226, they amended substantially. I am not going to the other details, but one clause was introduced, namely, that if there is any other remedy available, 226 shall not be exercised. Shall not be. It is not just optional. So now the other remedy, it is not the alternative remedy which the courts generally use it as a discretionary aspect for denying 226 jurisdiction. Article 323A and B were introduced in a whole chapter on tribunals. So the idea was to provide remedy under the tribunals and then say that this matter is covered by the tribunals and therefore 226 shall not be used. This was the whole obvious, so that, you know, by the time Keshavananda Bharati was in place, so wholesale taking away 226 might affect the basic structure or the fundamental features of the Constitution. Therefore, this particular methodology was adopted. So then came a whole lot of tribunals like the Service Tribunal, what we call it the CAT here in the center, and state tribunals all over, SAT, and starting with the Service Tribunal, as you know, Sampath Kumar's case to begin with, there was no judicial member at all in that one. It was just a set of retired officials sitting there. So Justice Bhagwati, delivering the judgment, he said, look, this is no tribunal. This can't be without a judicial member, so the whole thing has to be amended. And as you remember, comparatively recently, jumping several years, when the company law tribunal was started, there also there was no judicial member, so the Supreme Court in Gandhi versus Union of India has struck down and said that you can't have a tribunal without a judicial member. Then of course the Debt Recovery Tribunal and then Sikh Industries, whatever the tribunal is there, and I don't know a whole lot of it, because in Delhi, for example, if you just go on during the working hours, you will see black coats all around. What are they doing means they are not roaming around. There is a tribunal, because there is some tribunal or the other. So the lawyers are there. So the only summarizing the whole thing, I can say that it has certainly given employment to lawyers. But whether it is given relief to the public is a different question. Central Administrative Tribunal, for example, it started with the big difference that no appeal will directly to the Supreme Court, nowhere else. Supreme Court was fed up with the distance is so very close, near. So adjournment refused, transfer not cancelled, stay refused, appeal to the Supreme Court. And Supreme Court will ultimately dismiss it, but the docket in Supreme Court exploded to such an extent that they felt that but nobody was prepared to amend the law. So came the L. Chandrakumar case. L. Chandrakumar case where they say that look whether High Court, because it is just passing the buck, in the sense that Supreme Court said that if High Court can take it, we can easily say that High Court will do it. So L. Chandrakumar's case, when it came there, and if you see some very carefully, you will find my name as the lawyer for the Union of India. So I did appear for the Union of India, and the only instruction I had from the Union of India is that whatever you want to do, you please do it. We don't care. And then I said that how about if I say that the High Court has jurisdiction? He said, we don't mind. Somebody came and said, we don't mind. So anyway, the submission was that any tribunal means the High Court has jurisdiction under 226 and 227 to a certain extent, but 226 jurisdiction is there. So that cannot be taken away by any statute, and therefore High Court has power. So the Supreme Court directly coming has to an extent stopped. And I am not touching various regulatory authorities which have been come up of late, electricity, telecom, and so many things like that probably. And so we will hear from our distinguished speakers one by one, and they are all apparently have got considerable amount of experience of working in tribunals. And I reserve my judgment to the last, but it is going to be that they are earlier, many of them are abolished better. So that's because each one of the tribunals, some of them I appeared for as a sample, just decided not to go there again, and did not, kept up my promise to myself. So now let me introduce first speaker, Mr. Venugopal, Krishnan Venugopal, Senior Advocate, Supreme Court, and he has a string of degrees from all over the world, and studied this one because the Harvard, Stanford, I don't know, whichever the other thing, he had given me about one-page note which I don't want to read. So, and he has particularly specialized experience of WTO and the subsequent, the connected, and yes, anti-dumping. And but that is there a tribunal for anti-dumping?
No, it's a SESTAT.
It is yet to be established. So
no, SESTAT.
SESTAT. Okay. That is, I don't know that. So he has got the idea about. So I request Mr. Venugopal, And Venugopal name will be very familiar to you, and very famous advocate to the Supreme Court. That name is not going to be forgotten because he is going to carry forward for another 50 years. You can go here if you feel like. I mean, if you feel like. People will be still that
Ladies and gentlemen, it's a great pleasure to be here again. A few months ago, I had spoken on the subject of regulators and the tribunals associated with those regulators. So I'd like to begin by going back to what I had said then. Today, there is a certain schizophrenia associated with the topic of tribunals, mainly because of the confusion in the law associated with Article 323A and 323B tribunals. But I'd like to go back in time to much before the 42nd Amendment, which introduced the concept of 323A, 323B tribunals. Independent regulators and the tribunals associated with them really arose, at least in the United States and in India, out of the need to substitute regulation for freedom of contract, especially in times of crisis. In the United States, if you remember, markets collapsed in the context of the Great Economic Depression and the stock market crash of 1929. Money became scarce, people started trading in goods, that is in kind, instead of paying for things in money. It is in that context that Franklin Delano Roosevelt started the notion of regulators to substitute for the market. In India, it came about with the Defense of India rules, both during the First World War and the Second World War, when the British wanted to channel the economy into support for the war, that is the two world wars. You had regulators coming in to substitute for the market. Today, the context is extremely different. After the plans, the 5-year plans introduced by Prime Minister Nehru together with Mahalanobis, you had the state taking over great swaths of the economy, the commanding heights, etc. And in the post-liberalization context, you found that there was an enormous need to have independent regulators that would supervise state PSUs as the government tried to introduce competition into the market. If you really look at the way the economy is functioning today, most of us take it for granted, but most of us have forgotten that by the early 90s, when the government started to introduce competition, you had PSUs controlling huge sectors of the economy. SAIL, for example, SAIL controlled steel, Indian Airlines and Air India controlled aviation. You had in various other industrial sectors and service sectors, such as, for example, life insurance, banking, etc., you had government companies that controlled the whole sector. In order to increase efficiency in the economy, the government decided that they needed competition and to introduce the private sector. How do you ensure fair competition between state monoliths that monopolize the sector and private companies that were fledgling, companies that had just started in the area? for that, you needed independent regulators. Therefore, in that context, you needed specialized tribunals that understood market-related notions of regulation as compared to the traditional tribunals that are the subject matter of the 42nd Amendment and 323A and 323B. Another important point that we need to note, 323A and 323B really came about because Mrs. Gandhi and the government of that era wanted to take away powers from the High Court, emasculate them in a sense. Therefore, you had the notion in 323A and 323B, 323A being service law tribunals, and 323B being a host of other tribunals, including in taxation, land reforms, etc. You had this notion introduced in the Constitution of simultaneously conferring on these tribunals the jurisdiction and powers of all courts except the Supreme Court, and associated with that, the exclusion of jurisdiction of the High Courts under Articles 226 and 227. That was what Mr. Bhat was talking about. Now, one important difference between those traditional tribunals and the tribunals I'm talking about, those tribunals were strictly legal tribunals that dealt with questions of law in familiar areas that the high courts and lawyers all over the country are familiar with, that is service law, land reforms, taxation, etc. No great magic in these areas for ordinary judges, that is below the High Court, and High Court judges and Supreme Court judges to deal with them. In the post-1991 liberalization context, however, you have specialized tribunals that deal with areas of regulation that may not be so familiar to our judges and lawyers. Areas like airport regulation, competition law, especially post-MRTP Act, the insurance regulators, etc. Now, in this context, and this is the flip side of the opposition to 323A and B tribunals, if you left the role performed by these specialized tribunals to the high courts, they would have got stuck in the arrears and pendency before the high courts. It would have been impossible to have speedy resolution of important issues in these sectors by the high courts. Therefore, in my opinion, the issue of 323A and B tribunals and their efficacy should not be confused with the issue of the efficacy of these more modern market-oriented tribunals in various regulatory sectors. Apart from the issue of public sector companies that operate in these areas as the state receded from the economy and the need to deal with these state PSUs, there is the other issue that in most of these areas of regulation, you're dealing with natural monopolies, for example, electricity, etc. Electricity, airports, and so on. The need for cost plus regulation, if you will, so that as the private sector enters these areas, they don't take advantage of the consumer, is an important